Frequently asked questions, related party issues in a 1031 exchange. Related party issues can be fairly complex, and there's something where you certainly want to review any potential exchange involving a related party with your tax and or legal advisors. First off, who is a related party? A related party is any entity that is related to the taxpayer. So it can be a family member, a lineal descendant, so a father, a mother, a brother, a sister. Those are considered related parties. Keep in mind, step parents that are not related that way are not considered related parties. So that's not a related party. A related party can also be any entity in which the taxpayer has more than a 50% ownership interest. So if I'm an individual and yet I own 70% of the stock of a C corporation, it is considered a related party to me. And oftentimes this comes up where investors own a number of different properties and they own in different related entities. So maybe they've got an ownership interest in 15 properties, all in different LLCs and partnerships. Some that maybe don't have their name on the vesting, but they're considered a related party because they have over a 50% ownership interest. With the related party rules, there really are four different scenarios to look at. And what I want to do is briefly address them in this segment, and then in a further segment, we'll drill down into some different private letter rulings and tax court decisions. So here are the four scenarios. In a related party exchange, where it's a simultaneous exchange, it's a swap of properties. This is permitted. However, both parties must hold the property for a minimum of 2 years. So there's a mandatory 2-year holding period when properties are swapped among related parties. In a delayed exchange where the taxpayer sells to a related party, this is permitted and there is no 2-year holding period. Scenario number 3, a delayed exchange where the taxpayer wants to purchase from a related party. So I want to purchase, let's say, my mom's property. This is not permitted, and I've got a cite there of Revenue Ruling 2002-83 and PLR 974-8006. There are a whole body of PLRs and a whole body of documentation as to why you cannot purchase from a related party unless you fit into scenario number 4. Doing a delayed exchange, purchasing from a related party who is also exchanging. So the taxpayer purchases from a related party, and the related party, instead of receiving the taxpayer's proceeds, they work with a qualified intermediary and they buy replacement property C. So just to recap that, scenario 3, you cannot do a delayed exchange and purchase from a related party unless you fit into scenario 4, delayed exchange purchasing from a related party who is also doing a 1031 exchange. To review your specific 1031 exchange situation, contact Asset Preservation's headquarters in California at 800-282-1031 or our Eastern Regional Office in New York at 866-394-1031. Please read the full disclaimer, as Asset Preservation cannot provide tax or legal advice.